I find that the virtual signing and execution of court documents through electronic means provides simple benefits for legal professionals. This includes the ability to manage a sizable portion of their workload remotely. The legal professional no longer has to make multiple trips to the courthouse, legal aid, or other firms to validate miscellaneous client documents or forms. In extension, the time saved from electronically exchanging and signing documents allows the court to deal with the issue promptly. However, there are several ethical risks associated with e-signatures for legal professionals. Licensed paralegals in Ontario have a professional obligation to practice the law per the guidelines prescribed to them under the Paralegal Rules of Conduct. I find that the following rules under the Act may be a risk of being breached through the issue of electronic signatures. Rule 2.1 provides that paralegals are expected to uphold the standards and reputation of the paralegal profession and assist in the advancement of its goals, organizations, and institutions. Rule 3.1 and 3 on client confidentiality provides that paralegals shall ensure that information related to the business and affairs of a client shall remain strictly confidential. This applies unless it's authorized by the client or requested by court order. Paralegals are also expected to keep client documents and property out of sight or reach of those not permitted to view them. In the R versus Poussey case, the defendant, Mr. Poussey, was charged with fraud for electronically forging Mark Atson's signature on work contracts. Mr. Poussey testified that the agreement between his company and Mr. Atson's company, Fred Victor Center, was legitimate and was approved by them both. Moreover, Mr. Poussey insisted that any accusation of fraud against him was no more than someone trying to set him up. The evidence displayed in court quickly disproved that Mr. Poussey had been framed as he suggested. Mr. Poussey had copies of Mr. Atson's e-signature saved in 2 folders on his laptop and on a thumb drive in his office. The timestamps on the document proved that they had been modified. This case demonstrates the legal provability and security problems associated with e-signatures on negotiable instruments. The person relying on the signed document ultimately determines its reliability. Using e-signatures on court documents does pose an ethical risk for legal professionals, but it's not a significant one. Although there may be instances where confidential information be inadvertently disclosed to the wrong person, this is not directly tied to the issue of e-signatures. Therefore, there is no concern for a breach of confidentiality under Rule 3.1 and 3, so as long as the paralegal manages paperwork competently. Based on the R versus Poussey decision, I find that legal professionals are not liable for dishonest or fraudulent claims made on behalf of their clients if they are not aware that the claim is such. I believe that this satisfies Rule 2.1. Electronic documents and e-signatures allow court documents to be exchanged more efficiently than those sent through the mail. It also saves a lot of courier time with instant electronic delivery. As the use of e-signatures continues to be adopted into more businesses, I don't believe their use will decrease. I think the issues of legal provability and security could be eradicated if simple reliability standards for e-signatures were outlined under the Electronic Commerce Act. Thank you.